This starts as a routine hearing, but quickly shifts when Gary Michael Pelosa chooses to represent himself. His lawyer moves to withdraw, and the judge immediately questions his background and legal understanding. From the start, you can feel the tension building as the court hints that self-representation may become a serious disadvantage in this case.
Mr. Patterson.
Judge, we have Mr. Pelosa at the seat.
All right. I'll call State of Kansas versus Gary Michael Pelosa. Case numbers 26CR25 and 26MR19. And actually, that's an extradition issue. So we'll take up 26CR25 initially, and depending on how that gets resolved, then we'll proceed on to the extradition. So if counsel would state their appearances, please.
Gary Gear on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Gary Pelosa. Mr. Pelosa does appear from the Butler County Detention Facility. Judge, I do have an announcement to make. I have met with Mr. Pelosa. We've discussed his case. During that discussion, he did make it clear he wanted to represent himself rather than have counsel. We discussed that at length, as well as he has then thought about it longer overnight. So we've had a breakout room. We've discussed it again here today. And I can tell the court he does wish to represent himself and not have counsel. So based upon that, Judge, I'm asking the court to allow me withdraw.
Okay, Mr. Pelosa, is that accurate?
Yes, sir. I didn't know we weren't going to be in court today. I have motions here that I don't know how to get into court because the jail don't have mailing envelopes. I thought I was going to be in court so I can give it to your clerk. And I'm going to need to ask to push this maybe forward so I can find a way to get it into the court.
Well, Mr. Pelosa, what you're discussing is one of the complications of representing yourself. What's your educational background, sir?
I've got high school and two years of broadcasting school, and I graduated broadcasting school. So I had 14 years of school. And I had 2 years of business law.
All right. Why a person has a right to represent themselves. However, it is generally not considered to be a wise decision for most. Why is it you want to represent yourself as opposed to Mr. Patterson, who's an experienced attorney in this district? And
well, I'm going to tell you, I've advocated for prisoners in federal prison, and I have personally have gotten out 9 federal inmates myself. Also, in conjunction.
Well, generally, that's when somebody that's advocating for them, it's because they are a federal inmate of themselves. Is that correct? For you?
No. It's
okay.
Not correct for me.
Proceed.
So I'm just asking if I can get some time forward to get these documents into the court record.
Well, what's your experience in regards to filing motions and so forth?
I have a lot of experience in it, sir.
What is the nature of your motions at this juncture?
A notice in demand. It's really a notice in demand.
For?
I got evidence to bring forward, and no one's able to see. I mean, I wasn't even stopped. I was walking, but they said the registration.
Okay. Well, hold on.
I don't want to get into arguing anything.
Right.
So
now, do you understand what sometimes what I've done and other judges do is allow a person to represent themselves, but also have standby counsel available. Would you be receptive to that procedure?
No, sir.
Is there a particular reason why?
Right, because we haven't established the court's jurisdiction just yet. Sir, I'm one of the people, and I am the beneficiary for the defendant. You are a corporate judge, and that's a corporate attorney, and I'm one of the private people of this country. So I want to represent myself.
All right. Mr. Pelosa, are you going to be requesting a trial to a jury?
Yes, I will.
Is that one of your written motions that you have?
No.
Okay, in Kansas, on a misdemeanor, law requires a person to file a written request for jury trial. Again, on a misdemeanor offense, you're certainly entitled to that. But we set some earlier, and it looks like, well, we've got the next jury trial date is going to be February 25th. Are you going to be available and ready to go by that date? That's just a couple of weeks away, sir.
Well, I want discovery. I want the video of the officer's cam, and that's evidence in itself.
Well, and I understand that, and a certain amount of discovery is appropriate. Again, it's a lot easier with counsel, but
sir,
if you're okay, I'm going to set this matter for trial. The next date after February 28th is going to be in April, April the 8th at 9. So you could end up, remaining in jail for a good period of time. Is why I'm bringing these things up.
Okay, I'm still challenging the court's jurisdiction. I can challenge jurisdiction at any time. I mean, sir, let me ask you this question. Are you a member of the bar in good standing?
I've been a practicing judge for the last over 5 years, sir, and yes.
Okay, is the prosecutor a member of the bar in good standing?
Okay, I'm not going to go playing your games here, sir.
Well, we have a conflict of interest.
Sir, I'm going to set this matter down for hearings. Sarah, Jen, does Judge Webster, what's her next motions date?
Are you asking about a Monday misdemeanor control or a bench trial?
No, I'm not sure how she breaks that up. You tell me, I don't know the nature of all of his motions or how long that'll take. But it wouldn't be able to go on the expedited docket.
And Judge Webster would usually hear those on a Wednesday afternoon. That's when she has evidentiary type hearings.
Okay. Jen, can you look on that and see when she has next available?
The next available is going to be March 25th at 1:30.
March 25th at 1:30. So, Mr. Pelosa, at this time, I'm going to take your motion to represent yourself under advisement. I'm going to permit you to file your motions and not have Mr. Patterson do anything on that, but you need to get your motions on file. And that is one of the issues that, frankly, there's a lot of questions and I don't have those in front of me in regards to a pro se defendant. But we'll set that on that March. Is that March 25th at 1:30?
That is correct, Your Honor.
Okay. That's when your motions will be set. You'll need to file those. You have them ready to go now, sir?
Yes.
Okay. I want those on file by March 5.
How do I get them to you?
Well, I'm not going to explain how you have to do things.
Okay.
You say you know how to do all this stuff. I cannot advise you how to proceed on your case.
I'm not asking for advisement.
Yeah, you are. You're asking for procedural questions in regards to how to do it, and the court can't hold your hand and do that. That's one of the extreme disadvantages of representing yourself. So Judge will take those up at that time and make her decision in regards to Mr. Patterson, but I'm not going to require Mr. Patterson to do anything further on this matter. Mr. Patterson, would you be appearing on that docket as well?
Not normally, Judge, but I did put it down. If you are ordering that I continue as standby, at least for now, I put it down.
I would ask that you be there as standby right
I
now.
reject that. I reject that.
I know you do. And you'll get a full hearing on it, but today's not the day on that. That was not scheduled for today. So March the 25th at 1:30. That is in regards to 26 CR 25. All right. Moving on then to the 26 MR 19. Mr. Patterson, are you appointed on that case as well?
Because it is misdemeanor charges in Missouri, then yes, it does fall on my contract. But again, I've discussed that with him and he has the same position on that too.
Is that correct, Mr. Pelosa?
Yes, sir.
You'll need to file your motions and things on that. We'll set it for March 25th at 1:30 as well. So I'm going to, Mr. Patterson will be standby counsel on that as well.
I reject that. If he wants to take the consequences of it, let him so. If not, then he needs to go.
He's not asking for that, sir. I'm ordering it. So at this time, and it's going to be the same order that I just made.
What's your authority?
You're still going to, sir, don't interrupt. You're still going to have the opportunity to do that. I'm not asking him to do anything on your behalf in the meantime, but you're going to need to file your motions, and that's going to be difficult from where you're sitting. So, file whatever motions that you feel is appropriate, and it'll get brought up at that time as well. Again, that's on Judge Webster's calendar. But if you're going to be requesting a jury trial on these matters, you need to get those on file as well, because that April 8th date is on the court docket coming up fairly soon. All right. Is there any other issues that we need to discuss concerning either of these cases for Mr. Pelosa? Mr. Regier?
Your Honor, if the court is continuing the bonds in both these matters, the state has nothing further.
Mr. Pelosa, anything further?
Not at this point.
All right. I'm going to continue the bond status as they currently are. Mr. Pelosa, if you do make bond, you are ordered to appear before the court on that March 25th date at 1:30. You're to be there at the courthouse. If it's a Zoom hearing, then they'll do it through court security, but you are to be present at that time. Do you understand?
What if I'm in another county for extradited and I'm still in jail? So
that's another matter. I said if you were released, if you've made bond on your various cases, then and are released, that's the order. If you're in custody, typically these matters you take care of the local matters here that you're charged with, and deal with that, and then before a person is extradited. But so that's going to make a complication for you, perhaps, but that's your choice.
So if I may ask, the 26 CR 25 case, what is the 26 MR 19 case?
That's the extradition case.
Okay.
All right. It appears that on the 26th case, the bond is set at 10,000 cash assurity. So that'll continue to be the bond with the conditions that I just noted. Anything further concerning Mr. Pelosa?
Not from the state, Your Honor.
Very well. These matters are adjourned. Mr. Pelosa can be returned to lockup.
Thank you.
This is where control fully shifts back to the judge, who sets firm deadlines and trial dates while shutting down repeated jurisdiction arguments. The defendant continues resisting court procedure, but the judge pushes forward, maintains bond, and finalizes custody orders. The hearing ends with the defendant taken back into lockup. Like, subscribe, and see you in the next video.